I'm Brittany Lewis with Forbes Breaking News. At a House Judiciary Subcommittee hearing on Tuesday, Congressman Steve Cohen spoke about emergency authorities of the president. The Tennessee Democrats spoke about amending the National Emergencies Act. This would put guardrails on the president's exercise of emergency authority. Take a listen to his opening statement here.
Committee on the Judiciary Subcommittee on the Constitution, Civil Rights, Civil Liberties will come to order. Without objection, the chair is authorized to declare recess of the subcommittee at any time. I welcome everyone to today's hearing on examining potential reforms of emergency powers. A very serious topic which we have explored in the past and will explore again. We have established an email address and distribution list dedicated to circulating exhibits and other written materials and motions that members might use today. Send them to the email address if you'd like to do so that we previously shared, and they will be distributed. Finally, all members and witnesses should mute their microphones when you're not speaking. This will help prevent feedback, other technical issues, and you saying things you don't want to have heard. You may unmute yourself at any time when you seek recognition. I'll now recognize myself for an opening statement. It was fitting that our first hearing under my chairmanship of this subcommittee, which was in February of 2019, was on the National Emergencies Act of 1976 and its implications for one of the core tenets of the Constitution's design, namely a governmental structure defined by checks and balances and the separation of power. Nothing more fundamental in our system. The specific impetus for that previous hearing was then President Trump's attempt to invoke emergency powers in order to divert billions of dollars in military construction funds to build a border wall. We heard a number of broader and bipartisan concerns about the National Emergencies Act and Congress's delegation of emergency authority to the executive. The National Emergencies Act was enacted in 1976 in order to constrain the use of presidential emergency authorities. It does not give the president any particular powers, but it sets forth the process that he has to follow if he declares an emergency, and the process that we in Congress have to follow if we want the emergency to end. The Act sets out a procedural framework only and does not define what an emergency is. Congress passed the National Emergencies Act during a period of post-Watergate reforms after it became increasingly concerned that presidential emergency powers were becoming unwieldy and overextended. Before 1976, no statutory procedures existed for the presidential declaration of national emergency, and Congress had no defined supervisory role, checks and balances portion. It was a response to the abuses of the Nixon era that the Senate created the 1973 Special Committee on the Termination of the National Emergency, renamed the Special Committee on National Emergencies and Delegated Emergency Powers in 1974, which was co-chaired by the Honorable Senators Frank Church and Charles Mathias. The Special Committee issued its final report in 1976, emphasizing that emergency laws and procedures in the United States have been neglected for too long, and that Congress must pass the National Emergencies Act to end a potentially dangerous situation. It was against this backdrop that Congress passed that act in 1976. That was 48 years ago. Since that time, the National Emergencies Act shortcomings have come into view. For instance, one of the concerns we heard at our 2019 hearing about the limitations of the act included the fact that there's little in the act that would prevent presidents from renewing emergencies in perpetuity. The only mechanism that Congress has for ending an emergency without the support of the president is through a joint resolution of Congress, which requires the president's signature and is subject to a veto. The Act also does not require that any statutory powers invoked by a president relate to the nature of the emergency. In other words, the president can exercise numerous powers upon issuing an emergency declaration, even if those powers have nothing to do with the declared emergency. Exacerbating these concerns is the fact that, as many scholars and commentators point out, Congress has almost lost track of how many underlying laws exist that grant the president emergency authorities, or whether these grants of emergency authority remain warranted. Our witnesses will describe what some of those laws for us, many of which have never been used. Nonetheless, they remain on the books, and as Justice Robert Jackson put it in a famous dissent about a different claim of emergency authority, they, quote, lie about like a loaded weapon, unquote. In the 3 years since our previous hearing, members on both sides of the aisle and in both houses have introduced legislation to address the potential for a president to address these weapons. Broadly speaking, these measures would amend the National Emergencies Act to place more effective guardrails on a president's ability to invoke emergency powers and would reassert Congress's rightful place as a check on what would otherwise be be almost unfettered executive authority. For example, Title V, Subtitle C of the Protecting Our Democracies Act would amend the National Emergencies Act to, among other things, empower Congress to proactively approve a presidentially declared national emergency and require any national emergency declaration to expire after 20 legislative days absent congressional assent. It would also require that any emergency powers invoked by the President pursuant to a national emergency relate to the nature of and may be used only to address that emergency. Other proposals of note include the Article I Act, legislation introduced by Senators Mike Lee and Representative Chip Roy, a member of our subcommittee, that would also amend the National Emergencies Act to place similar congressional guardrails in the President's exercise of emergency authority. While the House Judiciary Committee no longer has legislative jurisdiction over the National Emergencies Act, makes no sense to me whatsoever, but several things around here don't. It was this committee that helped in drafting the act. I believe the Judiciary Committee has a continuing obligation to ensure that the Act's purpose in seeking to restore proper congressional check on the executive branch is being met. The American people deserve our continued vigilance on this matter. They deserve to know the President cannot rewrite the law, exploit obscure loopholes in an effort to abuse power or even just exercise it unnecessarily. I look forward to the hearing from our witnesses today and bring a range of perspectives about the issues. I hope we can have a productive and fruitful discussion about whether we as Congress can do more to constrain these type of authorities so they're used only in true emergencies and not as an end run around the Constitution. I thank Mr. McCleary for reinvigorating me on this subject and a group that he's chairing, and Ms. Gautier for returning to the country and continuing your pursuit of the truth.